Honorable Justice Uday Lalit, my very distinguished brother, Justice Kaul, and all the participants and invitees this morning, including my colleagues in the Supreme Court, Chief Justice of the High Court, judges of the High Court, and all of you members of NALSA and the state and district legal services authorities. I would have been happy to begin my presentation this morning with what luxury a judge can afford, which is to say that I agree with the erudite judgment of Justice Lalit. But I think, the luxury which I have as a judge, I may not necessarily possess as a speaker. So I'll make a very small presentation on a subject which is very close to my heart. Well, I have been invited here as a self-confessed geek on technology with a sprinkling of knowledge of where technology is taking us, but an awareness of my own limitations when coping with technology, which is so rapidly evolving. But I do believe that the limitations of my knowledge I try to cover up by the sense of enthusiasm over technology. I want to address this, why technology, and what is the relevance of technology to the work which we do. And I'd like to briefly put across a point of view to you by looking at the institutional aspect, whether it's the courts, the jails, the police stations, the forensic science laboratories. What is the core problem? The problem is the opacity of the institutions, whether ours or others in the state system. The second problem is lack of information. Look at it from the perspective now of the beneficiaries. From the institutional perspective, the lack of information, the opacity, leads to all the evils that we are so conversant with, and I need not dwell on them, whether it's in terms of lack of efficiency, arbitrary exercise of state power, or worse still, corruption. Look at it from the perspective of the beneficiaries. Most of the beneficiaries are illiterate. There's a lack of awareness about rights. This is compounded by a lack of resources. But overall, and above all, there is the disability itself of marginalization. Whether the marginalization be in terms of gender, whether it be in terms of caste, whether it be in terms of sexual orientation, in terms of lack of geographical opportunities, lack of education, or just socioeconomic want. So these are two ends of the spectrum, the might of the state and the position of the beneficiaries. Now, why technology? Technology, ironically, enables us to do something which the wings of the state don't do, which is simply put, to talk to each other. So technology today has become a powerful interface for different wings of the state to be talking to each other. Now, how do we talk to each other and how do we benefit from the use of technology? First, there is a need for us to institutionalize our processes. Don't do it in an ad hoc way. When you see a problem, attend to the problem. When you see injustice, reach out to injustice. That is what we do as judges every day in our lives. That's our duty. But we have to go beyond, which is to institutionalize our processes. Second, set up systems and processes so that a case which falls in a paradigm is treated uniformly with all other cases in that paradigm, not dependent upon the individual or the person who happens to be there at that police station or that forensic science laboratory or that hospital. Third, bring about a sense of accountability for the decision makers themselves. Fourth, monitor implementation. How successful are we in terms of the control which we wield over public resources, which are made available to our disposal? And ultimately, the object of doing this is to enhance quality, transparency, and access to justice. Now, what I want to posit this morning is that there has to be a shift in our thinking process in terms of our dialogue. And we must shift the stream from seeking justice, from a system which allows citizens to pursue their cause of justice, to a system which seeks out those for whom justice is meant by seeking out the beneficiaries. The burden then is displaced from the beneficiaries to those who are in charge of various facets of the administration of justice. Whether it be in terms of identification of the beneficiaries, creating a sense of awareness, or preparing a module for universalizing the delivery of justice. Now, just one statistic, the National Crime Records Bureau figures tell us that the number of under trials in 2020 was 3,71,848, up from 3,32,916 in 2019. You also have a situation, when I said why technology, you have 500 million smartphone users in India today. Now, while you have 500 million smartphone users in India today, which is an extraordinarily large amount, you also have 800 million who have no access to smartphones. That also emphasizes the importance of technology, but tells you the limitations of technology. We need to reach out through the 500 million smartphone users, but we also have to understand that the rest are still yet to come onto the technology. Now, having given you this broad framework, I want to tell you a few things which I obviously couldn't tell you yesterday, and now in the light of the discussions which have taken place over the last day and a half, to tell you where technology would lead us and what's our vision for the future. The core of the e-courts project, the core of technology in the Indian judiciary, is the case information software, CIS. We are on CIS 3.0, 3.2. We are now moving towards CIS 4.0. As the e-courts project is implemented, the entire district judiciary today is mapped on the core of the technology platform, which is prepared by the National Informatics Center, and there is a periphery which is being developed by all the states. Some states are ahead of the others. But the core is the CIS platform which we have prepared. Now, to my mind, the integration of the case information software with NALSA, the state and the district legal services authorities will instantly make available court records and information of convicts and under trials to legal services authorities to process and monitor jail petitions, appeals, status of under trials, among other things. We are at present working in very close association with the National Informatics Center for upgradation of the present version of the CIS to CIS 4.0. Under trials are at the core of this development exercise as we move towards CIS 4.0. Now, some of the salient features which we intend to tap and which would be of great and immense value to the legal services movement is that there has to be a strong, as we call it in the ICT area, a strong handshaking mechanism between courts, prisons, and the police stations. Now, the facility is being developed to fetch information from prisons in CIS 4.0 and the updation of prisoner IDs in the case information system. In other words, what we need to plan on is not that the prisons should make available data to the legal services authorities, but that the legal services institutions must themselves be able to retrieve the data without the intervention of any state actor. In technological terms, the solution is very simple. You use what are called as APIs, application programming interfaces, so that once an open API is available to NALSA or to the district or the state legal service authorities, you can retrieve every element of the information from the case information system which maps data of crores of cases pending and disposed of, and then you can really design your solutions. Now at present, a great deal of work has been already done. The e-prison software has been developed by the Ministry of Home Affairs in conjunction with the National Informatics Center, and it has provided a mechanism to share the data of under trial prisoners, for instance, eligible under Section 436A of the CRPC, under trial prisoners who have been granted bail but to whom release orders have not yet been given, convicted persons who are eligible for premature release, those who are entitled to but have not been provided with legal services. The E-Committee is presently working on the integration of CIS with the e-prison software, and the information will also be available with courts for appropriate remedial measures. So we are in the process of designing, and I believe this will be something which we look forward in the very immediate future, particularly in the light of the discussions of the last 2 days, to develop a proper mechanism to maintain under trial prisoners' data, including the date of imprisonment, the act under which the arrest has taken place, the sections along with the maximum imprisonment provided for the offences. We are also in the process of designing an alert mechanism for the judge regarding the status of under trials, including information about under trials who have undergone the period of imprisonment, vis-a-vis the maximum punishment which is provided for the offence. The creation of a single window system for processing of all jail petitions of convicts and under trial prisoners. Defining timelines for every process which must be followed with alerts if those timelines are breached relating to under trial prisoners. Communication of bail orders and release warrants to the prisons and the police stations. And the mechanism to maintain details of every convict and every under trial. So if you were to just do a Google search on the e-prison software, you will find portals such as the Citizen Service Portal, the prisoner data to the legal services, the e-parole module, the e-custody certificate, the prison inmate information as on the record, the e-mulaqat record, e-parole windows, the grievance submissions, and then prisoner data to the legal services authorities, and finally, the e-custody certificates. So a huge amount of work is going on within the system. And I do believe that now the need of the hour is for us to use technology to talk to each other not in person, but to use technology to link up our institutions so that those who are in need of justice do not have to access us, but that we provide access to all these people who are in need of justice. The NALSA, as well as the state and district legal services authorities, would really benefit very greatly by monitoring the status of convicts with the use of data on the National Judicial Data Grid. Among the facilities for monitoring convicts which have been and are being developed on the NJDG is the list of convicts lodged in various prisons under the jurisdiction of the respective high courts and the district courts. The name of the convict, prisoner ID, date of punishment, date of admission in jail, the nature of the punishment, the judgment, the warrant issued to the jail, interim orders if any have been passed. So this data will help us to identify convicts in need of legal aid and assistance. A very important facet of the work which we have to do is by special drives for training and outreach programs, both for citizens and advocates through the district legal services authorities and the Taluka legal services authorities. We have drawn up a training program for 2022. A very senior district judge from Tamil Nadu, Ms. Arun Mosi, who is member human resources in our committee, is working on this. Now, a letter has been addressed to all the Chief Justices for accelerating the ICT awareness and outreach programs to all the state judicial academies. And all state judicial academies are proactively conducting the ICT drive. 18,858 stakeholders were covered through the state judicial academies during January and June 2022. Now we have calendars, and our calendar accounts for district level quarterly e-courts programs at all district headquarters through the DLSAs. Taluka level quarterly e-courts programs at all taluk levels through the Taluka Legal Services Authorities. And village level e-courts programs at 10 villages of each taluk through the Taluk Legal Services Authorities for common citizens and litigants. Then we have special e-courts awareness programs for the DLSAs, the paralegal volunteers and panel lawyers, and special drives for taluka level advocates and e-court awareness programs at the taluk and the village levels. So I'm using this opportunity to appeal to all of you to please participate in these programs, which are being made available across India in a bilingual mode, in the language which can be easily accessed by citizens, by advocates, by law students. Finally, the law students. Law students in the 4th and 5th year are a very potent source for us to tap for the future. There is a deep divide in legal education in the country. At one end of the spectrum, you have the national law schools consisting of the best from different backgrounds. At the other end of the spectrum, you have law schools where there is barely any teaching. Some of them are student-driven, some of them only exist in name. But there is one thing which students across law schools share, and particularly students at the other end of the spectrum. And that important feature which they share is the awareness of reality. They may not have had the best of education in terms of their upbringing or background, but every one of them is deeply aware of the reality which exists in their villages and towns. Now it is therefore we have to tap these young law students before the system makes them desanitized to pain and suffering. I think the great problem of the legal profession and the great challenge to judging in today's times is that you get desensitized to pain. The young are not yet desensitized to pain. And therefore we have to tap the young before they get desensitized. They become as wooden with probably age and the repeated interface with injustice. We have to allow these students to conduct legal awareness camps through video conferencing so that they can reach out to wider audiences. They can perhaps deal with the grant of preliminary legal advice. They are smart enough, and with a little bit of encouragement, these are the students who will be really the torchbearers for our future. Technology today has given us tools such as the Telegram channel. The Telegram channel is an instant messaging and unidirectional communication device through which you can load information, transmit information, but the information recipient cannot either edit or change the information which you load. Now it is important for us, we have been very reticent. The Supreme Court has been very reticent. High courts are even more reticent. And the district courts who look up to the high courts are therefore even more reticent on the use of modern means of communication, including Twitter, the Telegram channel. I think this resistance to us to use means of communication have to change, because we can reach out to our citizens by only using the language of discourse which is today becoming so prevalent in society. Unless we as judicial institutions shed this resistance to adopting the means of communication which is so widespread in our society today, we would perhaps have lost the game. And I do believe we are already in the process of losing the game unless we shed this fear about what would happen if we use modern means of communication. That's been one of the great reservations about adopting live streaming. Judges across the board feel, well, what happens if I start live streaming my court proceedings? Will people start assessing us? Will we lose the sense of respect of the community if we live stream court proceedings? Yes, of course, some of us will lose the respect of the community. But we will lose the respect of the community by showing to the world at large how we conduct ourselves when we sit there on the dais. But that's also a reminder that we have to change the ways in which we have been functioning. There is a world of accountability at large. And I think we can earn the respect of the community at large, provided we adopt and come on to the platforms which are so prevalent in our society. The judicial institution cannot be left behind if we have to be the harbingers of change. Even in terms of the Lok Adalat module, the CIS, the case information software, allows for the Lok Adalat module in various facilities on the CIS itself, the allocation of the Lok Adalat, assigning the name and date of the Lok Adalat, assigning the members. There's a facility to add names of judges, advocates, and other members in the panel of the Lok Adalat. Multiple panels can be created for a single Lok Adalat. Assign cases, send notices to parties for settling Lok Adalat, sends SMSs to parties in a bilingual mode, in the language which people understand, assign cases to individual panels, mark settlements of cases, generation of reports, archival of cases. So I think I'll end really by saying that much of the work that we do is in the area of human interface. But the danger of human interface must also be realized that we have not institutionalized the work which we do. So much of the work which we do depends on the individual who is in charge of the institution. And I think the greatest example of that is my very distinguished colleague who is sitting next to me. Because the legal services movement has been transformed since he took over, just because of the sense of dynamism which Justice Lalit has brought to it. But I think what we need to do is to institutionalize what Justice Lalit has done. I'm not sure we can't clone Justice Lalit, but we can certainly institutionalize the work which he has done by looking for the future when we pass on the baton which we have to succeeding generations of administrators. I'm deeply grateful to Justice Lalit for having invited me to this platform, which was truly his baby and his vision. But it's been a great pleasure to meet all of you and to share a few thoughts yesterday.
Thank you, Justice Chandrachud.